In R.E. Dueck, the Saskatchewan Court of Queen's Bench considered whether Tyrell Dueck, a 13-year-old boy, had the capacity to refuse life-saving medical treatment based on religious grounds. Tyrell was diagnosed with cancer in October 1998, which required immediate medical intervention, including chemotherapy and amputation, as recommended by his physicians. This provided a 65% chance of recovery. However, Tyrell's parents refused consent to the proposed medical treatments due to their religious beliefs. In response, on December 7th, a court order was issued, finding Tyrell to be a child in need of protection. This granted the Minister of Social Services authority to make decisions on Tyrell's behalf. As a result, the chemotherapy treatments were initiated shortly after. However, after several treatments, Tyrell decided that he did not want to continue it any further. He believed in his father's words, who told him God would heal him, and that there were alternative non-surgical treatments in California and Mexico that had higher success rates. It's important to note that these non-surgical treatments were not medically recognized and had no evidence of health benefits. Additionally, Tyrell was professionally declared to have no developmental impairment, which could have prevented him from being competent. In March 1999, the Minister of Social Services sought a court hearing to determine if the protection order should be extended or terminated. As such, the main question before the court was to determine whether Tyrell was sufficiently mature enough to independently refuse medical treatment, thereby overriding the state's interest in protecting a minor's welfare. Given the influence of Tyrell's father and Tyrell's own misguided beliefs, in addition to other considerations, the Saskatchewan Court of Queen's Bench ultimately ruled that Tyrell lacked the necessary capacity to fully understand the relevant medical information or appreciate the consequences of the proposed treatment. If Tyrell was a mature minor, then his wish would have been respected. However, this was not the case. As a result, the court held that Tyrell was not a mature minor and issued an order extending the minister's authority to make medical decisions on his behalf. This case significantly impacts individuals navigating the healthcare system in regards to consent, capacity, and autonomy. For parents with children who are minors, this case highlights the limits of religious beliefs in refusing needed medical treatment when life or severe harm is at risk. In practice, this means healthcare providers have a duty to assess the capacity of minors thoroughly and may seek court intervention when there is a dispute over treatment decisions. To illustrate this further, we can look at another example. In R.E. Sampson, involving a minor named Kevin Sampson. In this case, questions arose about a minor's capacity to refuse blood transfusions due to religious beliefs. Like in R.E. Dueck, the court intervened, deciding that the minor lacked the capacity to refuse life-saving treatment. Basically, if you or a family member faces a similar situation, it's important to understand that while your beliefs are respected, they are not always prioritized over legal protections of a minor's welfare. As such, this reinforces that while individuals have significant rights to refuse treatment, minors are subject to protections ensuring their decisions align with their objective best interests and safety. Tyrell's case set a precedent for similar situations in the healthcare system at large. It highlights the balance that healthcare providers and courts have to maintain between patient autonomy and patient safety. It places an obligation on healthcare professionals to consider issues of patient capacity, in particular for minors. It also encourages healthcare professionals to pursue legal guidance when faced with ethical conflicts between patient autonomy and adhering to medical standards. From a broader perspective, Cases like Tyrell's compel the healthcare system to clarify policies on consent, capacity, and the influence of personal and religious beliefs in treatment decisions. In conclusion, Dueck highlights the need to balance individual autonomy with the ethical and societal duty to protect vulnerable individuals, particularly minors. It reinforces the importance of ongoing reflection and clear guidelines within the healthcare system on issues of consent and capacity, influencing how patients, families, and providers navigate complex medical decisions.